Uh, this is almost the final round of the formation of India's data protection bill. At least I hope this is the final consultation. Um, and you're all here, you're all subscribers. Thank you for subscribing to MediaNama. I hope you're finding our weekly newsletter useful. And of course, there's a daily free reads of the day newsletter that you can sign up for on our site. Some of you here are just for this one time. Just thought I'd let you know that the recording of this call will be available to annual subscribers, as well as recordings of all previous briefing calls, including the one that we did back in January when the JPC version had come out. But we have just about, I guess, a month or so, a little less than a month to go before submissions are due for this version of the data protection bill, or the way I like to talk about it, it's the data protection bill that isn't, because it doesn't do much to protect our data. We've got a whole bunch of stories up on MediaNama on the bill, and if you just go for the tag for the bill, you'll find all of our coverage where we've covered various aspects. There is more that we're planning to do. Amongst them, we're trying to do quick case studies or situations in which the bill will not be applicable, or we'll discuss how it is applicable. I've also asked our editorial team to look into my favorite data protection question regarding how Truecaller will be regulated. So hopefully that story will be out soon, especially because Truecaller poses a unique problem in data protection that someone else shares your personal details with Truecaller, and it's a tricky one, and whether that falls under this creation of a concept called deemed consent is something that we don't really know about. So we'll discuss all of those issues, but for this call, I let the team take over. They'll run you through the aspects that they've covered in their stories. This call, at least our presentation, is being recorded, but the Q&A that follows will not be recorded, so you can speak freely. Sarvesh, over to you.
Thanks, Nikhil. Let me just, so quick housekeeping. This is not any legal, business, or investment advice. And we are presenting selective information. It's not the full comprehensive coverage. So what we'll be looking into today, broadly, we'll be talking about what different companies have to do under the data protection bill when they're processing personal data, what rights do users have over their personal data, who all are exempt from this, what's wrong with the rights that are there, what are the various issues in terms of how the previous bills have explored these provisions, and how this bill is exploring the provision, how is children's data going to be treated, and can you transfer data outside the country? Will there be a data protection board? What are the functions of this board? And what happens if you violate any provision of this bill? So these are topics that we'll be covering broadly. And before we get into specific sections of the bill and talk about that, here are some of the definitions. Again, we've picked out ones that we think are important, and not all of the definitions, but here are some that will remain relevant throughout this presentation. And most importantly, we have personal data, which is defined as any data about an individual who's identifiable by or in relation to such data. Data fiduciary is a person who alone or in conjunction with other persons determines the purpose and means of the processing of personal data. And person is further defined as any individual, HUF, or company, any firm, and even if it's the state itself. So all these will be considered as data fiduciaries as long as they are determining the purpose and means of processing of personal data. Processing itself is further defined. It involves any kind of collection, dissemination, processing, sharing, storing of personal data. Again, there's like a lot of, it's a long definition. A lot of activities is considered as processing of personal data. Data principal is defined as any individual to whom the personal data relates, and it also covers the parent or lawful guardian of the individual if that individual is a child. And data processors, any person who processes personal data on behalf of a data fiduciary. So that's the key definitions to keep in mind. It'll make sense as we go on, and I'll just let Valerie talk about the obligations.
Okay, thank you, Saresh. So we'll start with this chapter on obligations of data fiduciaries. As we know, they have made a lot of changes to this bill, and an interesting concept that they have introduced is deemed consent. So what is deemed consent? Basically, it's when a data principal is deemed to have given consent for the processing of their personal data. Now, for what purpose this data will be processed, for how long, that is not given in this section. What is given are the situations under which this deemed consent will apply. So voluntary provisions, say you go to Chayos and they take your facial data and give you a cup of chai. So now you have deemed consent for Chayos to process your facial data. That is one example. You can see all the situations here on the screen. One interesting inclusion is that deemed consent will apply in public interest. And within public interest, they have included credit scoring and operation of search engines for processing of publicly available data. Fair and reasonable purposes is again something that comes under public interest. And here they have mentioned that this will be as may be prescribed. So this phrase will keep popping up throughout the bill from time to time. The rest of the situations you can see over there. All this being said, it's not as if consent is not mentioned at all. So in section 7 of this bill, it talks about how a data fiduciary or collector has to take the consent of the data principal, and the data principal can also withdraw their consent. But the data fiduciary can still process the data if they feel that it is required or authorized under any law. Another interesting point is in section 6 of this. It comes under notice. So the data fiduciary or collector has to give an itemized list of all the data points that that they want to process their data. And they have to give this list before they request consent. In the 2019 version, this was a bit more detailed. So it included, say, basis for processing personal data. This is not included in this current bill anymore. Another thing is that here consent only relates to processing of data. It does not, it is removed from, say, data retention or data collection. But still moving on to consent managers. So whether the data principal wants to give or withdraw or manage their data, that will be done, their consent, that will be done through the consent manager. Now, a consent manager is just a data collector who will maintain a platform for this purpose, and they will be accountable to the data principal, although they will be registered with the Data Protection Board of India. Now, this bill also makes a classification of somewhat of significant data fiduciaries and data fiduciaries. Now, the center can notify any one or a group of data collectors as significant data fiduciaries based on these factors that you see over here. One difference from the previous versions of the bills is that social media platforms were something that were considered significant data fiduciaries before, but they are not anymore, not in this version of the bill. Their obligations, however, remain the same, except record keeping. So record keeping has been removed from the list of obligations for significant data fiduciaries, but they still have to appoint the DPO, the independent data auditor. They have to undertake data protection impact assessment and periodic audits. Obviously, other obligations that come for all data collectors will also apply to them. So say the data fiduciary has to comply with this act's provisions, irrespective of whether the data principal is complying with them. Here again, an interesting point is that in terms of retaining personal data, so the data fiduciary has to remove data once the purpose is fulfilled, but it can still retain data if it feels it's necessary for legal or business purposes. Now, the example used in the bill is, say you go to a bank and you give your personal details to open a savings bank account. After some time, you will close the bank account, but the bank has the option of retaining your data even though you have closed the account. If say there are like KYC rules that say that they have to keep the data for 6 months or so. So that is the example they have used. Again, grievance redressal. So the previous versions were much more detailed in this aspect. Now they just have a one-liner that says that the data collector has to create mechanisms for grievance redressal. But in the older versions, they included a time limits. For example, say you have to address the complaints of the data principal within 30 months or 30 days or 2 months or so. The 2019 version said they could directly approach the data protection authority. The 2021 version tried to simplify this process. All of that is now condensed into a one-liner in the bill. Similarly, in terms of data accuracy, it's the data collector's responsibility to make sure that the data is accurate and complete. But in the 2018 version, they used to say that if the data is incomplete, then the data fiduciary has to take the steps to make sure that the data will be complete or something along those lines. None of that is specified here now. Again, it's just a one-liner here. What is removed from this bill, from this section that is of concern is privacy by design. So some provisions relating to privacy policy are removed from this section. Provisions that talk about how the method of processing personal data has to be transparent, that has been removed from this section. And safeguards for sensitive personal data is also no longer in this current version of the bill. So relating to obligations of data fiduciaries, this is all that we have covered so far. Now we'll move on to the next section, which will be covered by Mitaksh.
Thank you, Valerie. Good afternoon, everyone. Our data protection bill confers certain rights upon individuals to prevent or restrain continued processing of personal data. So let's look at what you're entitled to under the Digital Personal Data Protection Bill. Sarvesh, I'm sorry, I can't move slides. Can you just move on to the next slide? Thank you. So this bill entitles you to obtain confirmation of whether your how your personal data is being processed, and the personal data that has been processed in the past. You are also entitled to receive a summary of personal data being processed by the data collector or that has been processed by the data collector, which also has to include an overview of all processing activities that your personal data has been subjected to. Now, one of the key components under this section allows you to access identity of all data fiduciaries with whom your personal data has been shared. You are also able to access categories of personal data that were made available to data collectors, and all of this will be available under one roof. Next slide, please. You are also a data fiduciary is also obligated to comply with certain requests. You will be able to correct inaccurate personal data. You will be allowed to update your personal data and so on and so forth. Now, the most critical provision in this bill involves concerns right to erasure. You will be able to erase your personal data under a specific purpose. Let's look at right to erasure in detail. Next slide, please. Now, if you may remember, the 2019 bill and the 2021 bill enshrine right to be forgotten in their drafts, but the 2022 bill has no separate provision on right to be forgotten. Moreover, the scope of right to erasure has been severely reduced in this draft. You can only get your personal data erased only if it is not being processed for the purpose to which you had given your consent. You have no other avenues, which means that you cannot get your data erased for any other purpose apart from what has been mentioned in the draft. Now, it has been specified that retention can be done if it is necessary for a legal purpose, but that's about it. And it may be prudent to remember that there are a variety of reasons for which you may need to exercise your right to erasure. For example, you may decide to withdraw your consent. There is no clarity on how you will be able to get your data erased once you decide to withdraw your consent. If you come to know that your personal data is being used for marketing purposes, there is no clarity then as well, or your data is being used for unlawful processing. These are all the examples that have been collected from Europe's general data protection rules. Now, the dreaded as may be prescribed has made an appearance in this section as well. So we may get to understand the full scope of right to erasure in the future. But as things stand today, your right to exercise erasure has been severely reduced in this bill. Now, what happens when you have a problem with a data fiduciary? Now, the government has said that you will be able to register grievances with a data collector through an accessible mechanism, which again will be the responsibility of the data collector. If you're not satisfied with the resolution, or your complaint has not been addressed in 7 days, you can escalate your complaint with the Data Protection Board of India. Again, now, as may be prescribed, has appeared in this section, in this particular provision as well, wherein it says that a shorter period can be prescribed, shorter period than 7 days, that is. You also have the option of nominating an individual to exercise your rights in case of death or incapacity. Next line, please. Now, another glaring issue in this bill concerns right to data portability. That is to say, there is no provision on right to data portability in the 2022 draft. The JPC's draft had, in fact, gone a step ahead of 2019 draft and said that data portability could only be denied in case of technical non-feasibility. Whereas the 2019 draft had said that data collectors are allowed to deny data portability under the garb of non-feasibility or trade secrets. Now, most data protection bills have a provision on data portability. For example, you are entitled to transmit data to any controller without hindrance under Article 20 of the GDPR. Next slide, please. Now, there are also certain obligations that the bill has prescribed for an individual. You have to refrain from registering a false or frivolous grievance. You cannot suppress any material information, and you have to ensure that your information that has been furnished is authentic and can be verified. That's all from my end. Thank you so much. Akshit will take it from here. Thank you.
Hello, everyone. My name is Akshit, and I'll take you through the protections offered regarding children's data in the DPDP. So these are additional obligations that data fiduciaries have to follow in addition to the obligations that have already been mentioned by my colleagues. So these are just additional obligations. The first obligation is that data fiduciaries need to obtain verifiable parental consent before processing any data related to children. So this, I think, is a very interesting provision, because it begs the question of how companies like Facebook or any website, any e-commerce website, gaming website will be able to obtain verifiable parental consent. How will a company verify that the person giving consent on a website, which is like miles away from US, Facebook is in US and I'm sitting in India, how will someone verify that the person giving consent is actually my father if I'm a child? So this is a question that this clause raises. If you look at the previous drafts of the data protection bill, they only talked about parental consent. This is the first time that the word verifiable has been introduced, which means when consent of a parent is obtained, you need to verify it somehow. So which
basically means, Akshit, that they'd probably do Aadhaar authentication, right? That's what they treat as verifiable. Or they would do some kind of facial recognition based consent. That's the only meaning of verifiable that I can think of here.
Yeah, so that is probably the way that the companies could go, one of the ways. And looking at the next part, it talks about age of consent. If you look at this bill, the definition of child is anyone below the age of 18 years. Now the question is that the right age? Because because effectively you are treating a 3-year-old or a 4-year-old child in the same way that you would treat a 17-year-old person. If a 17-year-old guy wants to access a website like Facebook or Tinder or gaming website or a porn website, then would that person need to get consent from their parent that is verified? These are the kind of questions that this particular clause raises, which it's interesting to see how companies will navigate through such clauses. Now, additionally, this can also lead to discrimination, because the question is, are parents the right people to decide what is right for the child, or in terms of accessing on the internet? A parent might be biased in terms of gender. Boys may be allowed to access certain websites which girls may not be allowed to access if a parent feels so. So these are the kind of intricacies that the verifiable parental consent can lead to, and there can be an interesting discussion on these provisions. Moving on to the next obligation, it talks about targeted advertising. So data fiduciaries cannot undertake targeted advertising, tracking, and behavior monitoring. That's what the bill says. Now, again, data fiduciaries are not just online companies. It is important to note that data fiduciaries can be offline companies like a coaching institute or a tuition which collects data from children. So how these businesses, these organizations working for children or working as a business for children will be impacted due to the provisions which do not allow targeted advertising, tracking, and behavior monitoring. Moving on to the next slide. The third obligation is that any processing of data, any processing of children's data should not cause harm to the children, the bill says. At first, it seems like a blanket protection where children are protected from all harms that processing of data can cause. But there is a specific definition of harm mentioned in the bill. The definition lists 3 or 4 harm, a couple of harms like bodily injury, distortion, theft of identity, etc. Although certain harms are listed, this is a very trimmed down definition of harm. The 2021 version of the bill had an expansive definition, which included things like blackmail, extortion, etc., which have been removed from the 2021 draft of the same bill. Moving on to the next slide. Protecting children's data exceptions. Now, the bill lists certain exceptions for the clauses. First, certain data fiduciaries can process children's data without obtaining verifiable parental consent. Certain data fiduciaries can target advertising, track behavior of children. But what kind of data fiduciaries can actually do that? That is not clearly mentioned in the bill. The bill just says that these things may be prescribed later. That's what it says. However, it is important to note that there is no exception from the clause about harm. So no data fiduciary in any case can process data that causes harm to children. This is made very clear in the bill. Talking about penalties, under this subsection, penalties up to 200 crore can be levied on a data fiduciary. So that's it. That's all about children. Now we'll move to Data Protection Board.
Hi, everyone. My name is Aarti. So the Data Protection Board of India essentially upends the Data Protection Authority that was visible across 3 previous drafts of this bill. And it essentially exists and is established in the Act to as the foremost authority that will determine non-compliance with the Act and then subsequently impose financial penalties as well. Because it's a new body, it's sometimes difficult to do a one-to-one comparison with the DPA because they're different entities. So what I'll do first is essentially go over the main functions and powers of the board. And then after that, look at how it departs from the Data Protection Authority on different specified parameters. So as I mentioned earlier, the foremost function of the board appears to be determining non-compliance with the Act and then imposing penalties subsequently. However, it's interesting to note that the section dealing with the board also states that other functions can be assigned to the board under the Act or any other law by the center via a Gazette notification as well. Similar to the Data Protection Authority, the board can also issue orders during emergent situations like a data breach. So it can issue orders to mitigate harm and ensure that the negative fallout is sort of minimized as much as possible. And interestingly, there's some amount of legal immunity that appears to exist for the board as well. So no legal proceedings can be brought against it or its members for actions that it's undertaken in good faith under the Act as well. So that's something interesting to keep in mind when looking at the overall structure. As for its operations, according to the bill, it's intended to be an independent board and also one that's largely digital by design. So if you're looking at whether it's filing a complaint, receiving a complaint, and then, delivering the final pronouncement on it, all of that is largely supposed to be done through a digital office. Complaints can be acted upon, various types of complaints can be acted upon by the board. That includes a complaint made by an affected person, a reference made by a central or state government, by the center or a state government, a direction from a court, or it can also be a complaint related to a data principal's own non-compliance with its duties under Section 16 of the Act that Mitaksh just discussed. So those are the kinds of decisions that the board can take and sort of the manner in which it will take them. As for who's going to be taking those decisions, we actually still don't know just yet. A lot of the information on the composition of the board and who will be selecting its members still, as Mitaksh should say, is under the dreaded provision of as may be prescribed. We don't actually know how any of it's going to happen. What we do know is that the chief executive of the board who will be managing its day-to-day affairs, he or she will be appointed by the center on terms that the center has defined. So that's something to keep in mind when we're also thinking about the board as an independent body adjudicating on non-compliance with the law. Now, as for powers, unlike previous versions of the bill, there aren't actually specifically demarcated sections or chapters talking about different powers. But once you go through the bill, you realize that there are certain broad trends that you can capture through it. So the first one I would say is initiating proceedings. So the board has the power to essentially take a complaint and then initiate proceedings to decide if it has enough merit to proceed with an inquiry. If it doesn't, you kind of just stop in your tracks there. If it does, you proceed with the inquiry. It also has the power to recommend alternate dispute resolution. So if it feels that certain cases might be better handled by mediation or other unspecified processes, it can recommend that as well. If we choose to go with the investigation by the board has the power to actually conduct inquiries into the matter and investigate the issue fully. In this scenario, it has the power to summon individuals, to examine them under oath, and also to examine different kinds of documents that are submitted as well. And to prevent any further untoward non-compliance with the Act, it also has the power to issue interim orders restraining certain kinds of actions. Now, as a result of the inquiry, naturally, it has the power to also decide outcomes on the inquiry itself. And these are all enforced as if they are civil court decrees. So essentially, there are different types of outcomes that we have gleaned from the bill so far. In some cases, the board may determine at any point of the investigation that the claim simply lacks merit. In such a case, it can issue a warning or a penalty towards the person who raised it. If, however, the board establishes merit but says that the case of non-compliance is insignificant, they'll close the matter. And if it determines that non-compliance is significant, it will then proceed to impose a financial penalty. And these financial penalties are specified under Schedule 1, and I'm not going to go into the different types because Sarvesh will cover them at a later stage in the presentation. But various kinds of factors have to be considered while allocating them. So the first important thing is that they should not exceed rupees 500 crores in each count. And also, you have to consider different kinds of parameters while imposing them. So what is the nature and the gravity of the non-compliance? What kinds of personal data were affected? And whether the actual penalty that you're proposing is proportionate to the non-compliance that supposedly took place. And all of these orders that the board issues in these cases are binding to the involved parties. They are enforced as if they are a civil court decree. And if you want to appeal them, you can do that. You have to approach the High Court within 60 days of the order's pronouncement in such a case. Now, the board also has the power to review orders. So it has the power to review them, potentially withdraw them, suspend them, cancel them, or modify them as well. So, I mean, there is a chance of flexibility after a final outcome as well. And I think the final thing that's interesting and new, because a lot of these powers sort of broadly appear across the three versions, but this is interesting, is voluntary undertakings. So if you look at the bare text of the draft bill, it says that the board may accept a voluntary undertaking in respect of any matter related to compliance from any person at any stage. And this is not something I particularly understood until Savesh stepped in about 1.5 hours ago. And that's when we looked towards the Singapore side of things, because Singapore actually released guidelines on its own data protection law in October, where it clarifies voluntary undertakings. And it's interesting because the Indian government has also referred to Singapore's law while drafting this one. And in it, it sort of explains what voluntary undertakings are. So assuming in Singapore, someone is allegedly not complying with their data protection law, instead of the commission initiating a full investigation into that complaint, the defaulter can propose a voluntary undertaking where they propose to take certain remedial measures to curtail the non-compliance. And according to the Singapore government, this allows data collectors who have really good accountability mechanisms in place. It gives them the freedom and the time to undertake remedial actions without actually being penalized towards the end. And the Indian government may be thinking along similar lines, I can't say explicitly, but if you look at the explanatory note that accompanies the law, it's clear that they included the provision because they wanted to fasten the admission of matters at the board and also ensure that compliance is the norm as opposed to imposing penalties. So they want people to be compliant on their own steam. So that's essentially what a voluntary undertaking is through cross comparison. So if the board accepts one in the Indian context, then proceedings in the complaint stop. And if anyone violates the provisions of the voluntary undertaking, then the board, after giving the person a reasonable opportunity to be heard, can proceed with penalty as well. So I would just like to go to the next slide. I'm not able to. Could someone? Yes. So that's a general overview of what the board is. Now to kind of look at how it links back to the Data Protection Authority of India that was proposed in 2018, 2019, and 2021. As many stakeholders have told MediaNama, the DPA had vast responsibilities, and these ranged from adjudicatory responsibilities in terms of determining non-compliance to executive responsibilities of enforcing the act, to advisory responsibilities of actually advising state and central governments on compliance. And this is just a range that I'm highlighting here. The actual list is much longer. And it also even had a separate wing within it that would determine and then decide penalties, an adjudicatory wing, so to speak. And many stakeholders said that this is a bit of a confused outlook, and it also raises huge capacity concerns. Will the authority be able to do all of this? Will a single body be able to do all of this? Many proposed the idea of state-level DPAs. So there was a lot of confusion and concern over its functioning and its remit. From the current version of the bill, these appear to be whittled down. Like I said, the primary functions appear to be determining non-compliance and then imposing a penalty. But we don't actually know if that will stay the same because, like I said, the center has the power to notify additional functions under the Act or other laws as well. So things could change, but right now they appear to be this way. Coming to the penalties part, like I said earlier, separate adjudicatory wing typically dealt with penalties and imposing them. That's actually being done away with in this case because the mandate has shifted of the board itself. And also that wing had the power to award compensation to people who had been affected. And that's also done away with this draft version as well. So that's an interesting departure in terms of justice in the case of data protection violations. And finally, the Data Protection Authority was uh, critiqued for being heavily bureaucratic in terms of the proposals, at least lots of government secretaries and bureaucrats populated both the committee and the committee that was selecting the members of the authority. And of course, this raises concerns of executive oversight in a body that's supposed to be doing, a judicial function, so to speak. We don't actually know if that's changed because the main executive will be appointed by the center, and we don't know what's going to happen with the case of members and the selection committee because those rules just are yet to be prescribed. So it is a departure, but in which direction we don't know just yet. So that's just a roundup of the Data Protection Board of India and how it fares in comparison to the DPA. And I'll now be handing over to Sarvesh to discuss certain exemptions given to the government as well.
Coming to how the government fares under this bill, by default, we have all government agencies considered the same as any other company, any other data fiduciary. But then there is a power for the central government to exempt any of its instrumentality. So basically, it can exempt, for example, the Ministry of Defense or the Ministry of Home Affairs on certain grounds. For example, it can be, so the listed grounds over here are integrity, sovereignty and integrity of India, security of state, friendly relations with foreign states, maintenance of public order, or anything related to all of these above factors. And these are just all that is required for the central government. There's no other limiting clause saying that there should be some safeguards, there should be some oversight mechanism, nothing of that sort, which was there in the previous bill. We will look at that previous bills as well in the next slide. But these are the broad powers they have. And instrumentality is another interesting word over here. Previous bills didn't say instrumentality. It's not a word that's defined in the law. It's determined on a case-by-case basis. Previously, law enforcement agencies have been considered instrumentality. There have been court cases where airports have been considered instrumentalities of the state. And even public universities have been considered. Broadly, what the trend has been is any entity that receives government funding to an extent or any entity in which the government has certain level of control is considered an instrumentality of the state. And all of these can be exempt from any or all provisions of this act. And another important feature that's there in the 2022 bill, which wasn't there in the previous bills, the government and its entities can retain any personal data for an unlimited period of time. I think we had mentioned in the obligations section about how data can only be retained until the purpose is served or for any other legal or business purpose, but none of that applies when it comes to government entities. How has this changed from previous versions of the bill? 2018 bill, which was drafted by the Sri Krishna committee, that had some of the uh, most amount of safeguards when it comes to government access of data. So what it said was government can access for welfare functions if some other law allows it. But when it comes to security reasons, they have to make sure that this access and processing is necessary and proportionate. And there also, again, has to be a law which allows this access, even if it's for security purpose. And data could only be retained until until its purpose is served. The 2019 bill is when things changed drastically and none of the safeguards which were there in the 2018 bill was there. Essentially on the same grounds as the 2022 bill, security, public order, integrity, and sovereignty. So all these were grounds under which the government could exempt in the 2019 bill. But even then, there were some safeguards. For example, the government had to record the reasons in writing. They had to only do so if it's necessary and expedient. And they also had to put out the procedure, safeguards, and oversight mechanism that the exempted agency must follow. The 2021 bill again had the same grounds, public order, security, but again, it had the safeguard which says any exemption should be just, fair, and reasonable and proportionate. None of these limiting clauses exist in the 2022 bill. What are the other kinds of exemptions in this bill? The central government has the power to exempt a class of data fiduciaries based on the amount of data they process and the amount of users they have and what kind of data they're collecting. But who exactly is this class of data fiduciaries? We don't know. It could be a provision that the government uses to exempt smaller companies so that they are not subject to all the same obligations that bigger companies are. It could be to exempt financial sector because financial sector is regulated by the RBI. But as of now, it's not clear who it can be. And that's a problem because we don't know on what grounds the center can exempt a class of data fiduciaries, for how long and for what reason. Some exemptions that have been carried on from the previous bills. Law enforcement agencies for the purpose of prevention, detection, investigation of a crime or any other offense under any other law do not have to comply with most of the provisions of this bill. To the courts, if they issue an order and if there is any legal right or claim that has to be enforced, that again doesn't have to comply with the bill. And interestingly, this bill now says that the personal data of those outside India, if they're processed by an Indian company, the Indian company does not have to comply with this bill for those individuals. So essentially, if an Indian company is processing the data of someone in another country, they can process it as per their contract with that person and not as per the rules of this bill. That's a new addition in the 2022 bill.
Yeah, this is essentially the BPO exemption, Sarvesh.
Yeah.
The big issue that the BPO industry had with this versions,
exactly.
especially around cross-border data flows and
Yeah.
adequacy, it addresses those.
Yeah, that was one of the concerns of the BPO. Yeah. And the last exemption is the central government can again exempt certain entities if they're doing work for research and statistical purposes. Over to Arjun.
Hi guys, good afternoon. I'm Arjun here, and I'll be talking about data breaches in this new digital personal data protection bill. So firstly, we'll start off with the definition of data breach, which is available here on your screen. So one of the notable aspects that has changed from the previous version of this bill is that non-personal data, that is NPD, has been removed from the scope of this bill. So, and consequently, those of data breaches. So only breaches of personal data are being considered. Breaches, unauthorized use, processing, sharing, etc. of pertaining to personal data is being considered in this bill. So another point that Aarti has already made is that the board, the data protection board, will be responsible for determining whether a data breach has happened, its extent, and the penalties that it will impose on the data processors, also the fiduciaries. And these penalties will be civil penalties. This is something Aarti has noted, along with the fact that the board can prescribe urgent measures to mitigate the fallout of like any kind of data breach that occurs. So this is about the definitions. And now coming on to the safeguards and reporting aspect of data breaches. So the 2022 bill mandates that data fiduciaries should undertake reasonable security safeguards for keeping their personal data of principals safe. And how this has changed from the 2021 version is that some other measures or criteria that should be included in these particular security measures were listed earlier in that bill, but have been omitted in this version. And then another notable change over the last version of the bill, the 2021 and earlier versions, was that earlier it was not mandatory to report data breaches to data principals, only to the erstwhile Data Protection Authority. It was only mandatory for data processors or fiduciaries to, report incidents of data breaches to the DPA. But now it has become mandatory to report it to data principals also. And secondly, in terms of reporting timelines, the 2021 bill had fixed it at 72 hours with the rationale that this will fix accountability and reduce ambiguity in terms of reporting. But the new 2022 bill has left it to be prescribed later and has not mentioned it in the text of the bill. So now we come on to penalties for non-compliance. So the penalties that are imposed for not complying either with the security safeguards or for failure to report adequately or with as prescribed by the proper measures has been given the highest band of penalty, that is rupees 250 crores and rupees 200 crore respectively, as you can see. And another point to be noted is that the board can only issue penalties to the data fiduciary. It is not compensation to principals. And the principals may also be penalized for frivolous complaints, inaccurate information, and other grounds. So there are some qualifying factors that the board will consider while imposing penalties, such as the recurrent nature of non-compliance, the kind of personal data that has been affected by the breach, how whether or not reasonable measures were taken, to what extent they were taken, and there are several other criteria that the board must consider while like deciding to take appropriate action in cases of data breaches. So this was a brief section, and that is all from my end. I'll be handing over to Aarti to talk about the next section. Thank you.
Thanks, Arjun. So the DPDP bill is really concise in its provisions on cross-border data flows. What took up at least 2 to 3 pages in previous versions of the bill takes up a paragraph in this case. So I'm just going to go over the paragraph and what it is that we know about it currently, and then we can kind of look at how it compares to past versions, if it does at all. So the single sentence section 17 essentially says that data collectors can transfer personal data abroad to countries that have been notified by the central government. And it's presumed within this section that the central government is undertaking a kind of assessment before notifying these countries. But because this is all the section says, we don't know what that assessment procedure is or on what basis countries are going to be selected and then notified. Section 3 of the Act does quite clearly stipulate, though, that the Act's provisions are interpreted to also mean rules underneath it. So we can perhaps assume that subsequent legislation might clarify that in the future as well. And alongside this, certain cross-border data flows of personal data in this case are also exempted under some of the exemptions that Sarvesh had mentioned. So this is the last slide that he was referring to, where personal data processing for legal purposes or, of a person inside India with a person outside of India, those are all exempted. So these are also subject to that as well in certain cases. I think what's interesting here is not necessarily the exemptions, but the context that they're grounded in. And if you look at the explanatory note that accompanies the bill, it essentially says that at times national interest and public interest supersede individual interests. So I think that's an important factor to keep in mind when we're looking at exemptions and how they might shape cross-border data flows outside of India as well. So in terms of what's changed with previous versions of the bill, I mean, almost everything. Section 17 exclusively applies to personal data. And actually a section on specific to personal data cross-border transfers only appeared in the 2018 version of the bill. After that, the 2019 and the 2021 versions specifically applied to cross-border data flows of sensitive and critical personal data. These were types of personal data that posed higher privacy risks and harms to data principals, and hence they were subjected to much more stringent provisions when it came to transferring them abroad. And I think we see that with the 2021 JPC bill as well. Transfers of certain kinds of data can only happen if they're jointly approved by the center and the Data Protection Authority, if they don't affect India's national interests, et cetera, et cetera. So all of that is done away with essentially. So now we just have to assume that personal data, which is defined in the bill as any data about an individual who is, which is defined as any data about an individual who is identifiable by or in relation to such data. We just have to assume that sensitive and critical personal data fall under that larger umbrella category as well. We also see that this sort of
I just wanted to jump in over here because one of the complications, and I raised this before, that the definition of sensitive personal data and the undefined nature of critical personal data was creating was, let's take, for example, something like Naukri.com. And if you have caste in a resume as sensitive personal data, and someone just puts their caste details on the resume, uh, how is a how are they supposed to decide or even algorithmically determine that that particular resume should be treated as sensitive personal data? So just the complications that were created because of these definitions made, we would end up treating everything as sensitive personal data, and therefore restrict processing outside the country, which made them untenable. So I think this is actually a really good move by the government to simplify and stick to, at least for now, one definition, even though, of course, critical personal data is probably eventually going to get defined.
Thanks for that, Nikhil. There's a counter argument to that Sarvesh will bring up in his final concluding slides as well. So moving on from there, we also see that provisions for data localization in previous iterations of the bill essentially disappear in this one. I think we most strongly saw them in the Joint Parliamentary Committee report, where it really batted for bringing foreign data back to Indian shores and also advocated for eventually developing a policy for data localization. And we also saw that different types of data, so sensitive data, critical data, those had to be stored within India as well. Now, this saw resistance from a lot of companies, from startups, just on grounds of, as Nikhil mentioned, logistics, feasibility, all of that. It also saw criticism from governments, and we saw that with the US's comments earlier this year on how data localization provisions can impose high costs for different competitors in the market and may actually act as a market barrier more than anything else for India. So that's sort of what a significant departure to see nothing of the sort mentioned in the bill. And then the final thing that I'd like to touch upon is penalties. So in 2018 and 2019, the versions of the bill were fairly specific. They said that violations related to cross-border data flows of personal data will invite a penalty of up to 15 crores or 4% of the global turnover for the preceding financial year, whichever is higher. 2021, we saw a premonition of as may be prescribed, where the JPC essentially said that cross-border data flows violations will invite penalties as may be prescribed. 2022 doesn't actually specify explicitly penalties for cross-border data flows. That being said, Schedule 1, which is where all these penalties are listed, lists penalties for 5 specific offenses. And then there's a 6th provision which says penalties for any other provision apart from these 5. And those can invite fines of up to 50 crore. So that's potentially where cross-border data flows could fall in that bracket of up to 50 crore. But of course, how these matters will be dealt with and in what ways really remains to be seen. And finally, I just want to add, when we're looking at how the center will notify governments, there were source-based reports from around last week, which suggested that that might happen on the basis of adequacy and reciprocity, essentially. But they didn't really elaborate further, but that's just something to keep in mind when considering the flow of information between specific countries in India. So I would like to hand over to Sarvesh right now for the next slide.
Briefly looking at the penalties. So this is this table shows all the options that the Data Protection Board has for levying penalties. This is the entire list of penalties that are applicable. Number 6 is up to 50 crore. That's what will apply in most scenarios for most of the violations under this act. But specific scenarios we already talked about, when it's regarding failure to secure, or when it's secure personal data or report a personal data breach, that attracts the highest, which is up to 250 crores. Children's data, not processing it according to the bill, that attracts 200 crores. And interesting thing over here, number 5, non-compliance with section 16. That is essentially the section that gives duties to users. Duties of users include providing accurate information, not making frivolous complaints. So if users are found violating that, they can be levied a penalty up to 10,000 rupees. So that's something new in this bill. one thing you'll notice is that there's only financial penalties now. There is no criminal penalties. No one is going to be arrested. There is no term of imprisonment for any violation. Penalties will be determined by data protection. Although it doesn't say that turnover or revenue will be used, it's not explicitly mentioned anywhere. The board can consider these factors when it's issuing the penalty. There's no separate penalty for government offenses. Previously, we had the government, the head of the department that committed the offense was held liable, and that head could then investigate and find someone else who's liable. So none of that applies. Government is considered the same as any other data fiduciary for the sake of offenses. And the schedule, which is the previous, the graphic in the previous slide, that schedule can be modified by the government. The only limiting clause is that the government at any point cannot modify any of those penalties to be more than 500 crores. So that's a brief overview of the penalties. Non-personal data, you would have seen this is towards the end because non-personal data is no longer a part of the data protection bill. It does not fall under the whole Personal Data Protection Act. Last year's bill was the first one. 2021 bill was the first to actually bring non-personal data under its ambit. And back then we had the JPC say that it's hard to distinguish between non-personal and personal data. How will you actually segregate it? A lot of data is intertwined in a way that even non-personal data needs privacy. There is privacy in non-personal data as well. And that was their justification for including it as part of the bill. But none of this, we don't know what the justification for excluding it is now because there's no
Well,
accompanying.
in fact, if I may remind you, one of the members of the JPC at the MediaNama event that we did in December on the data protection bill said that they wanted privacy protections to apply to non-personal data. So that was I think that was Amar Patnaik. That was a factor that we hadn't considered previously, but on the whole, it's interesting to see NPD completely booted out of this bill, especially since there is no clear need for what's not personal data to be in what is meant to be a personal data protection bill.
Yeah, the term doesn't appear at all in this bill. At least in the previous bills, there was some options for the government to regulate non-personal data through separate regulation, but none of that features in this bill. And there are people who have welcomed this because critics have felt that non-personal data requires its own separate soft touch regulation and should not be part of this. The NPD expert committee, which actually has submitted its report on non-personal data, they also did not want NPD to be part of the PDP bill. They said that there should be separate regulation, there should be a separate non-personal data protection authority. So it seems to be more in lines with that thinking, the 2022 bill. A quick roundup of the concerns. We have covered these in detail in specific slides, but one thing you would have noticed is we have mentioned the phrase as may be prescribed many times. What this essentially means is that the center will come out with rules to describe their provisions later on. The problem with this is that a lot of these rules can be overbroad. It can sometimes go beyond the scope of what this act proposes, and these rules are not subject to the same rigor that the bill is subject to when it's being presented in the parliament. So the best example is take the IT Rules 2021, which was issued under the IT Act. Like most of the court cases against the IT Act is that IT rules has gone beyond the scope of the IT Act. So we can expect similar kind of concerns with the rules that are being that will be issued under the Data Protection Act if the bill is passed as it is. Deemed consent being too broad, that we've covered. The dilution of user rights, some of the rights have been omitted, some of them have been withered down. There's no specific mention of purpose limitation, data minimization, which are some core principles to personal data protection. The explanatory note actually lists all these, saying that this is what the bill is doing, but the bill itself does not actually contain these terms or any direct reference to these terms. The independence of the Data Protection Board, RTS covered that. The broad powers of the government to exempt itself, exempt a class of data fiduciaries. Penalties on users, that's something new. Reduced information in notices. Earlier, they had to show who all the data is being shared with, and for how long will the data be retained, and all these do not have to be shown when seeking consent with the new bill. there is lack of clarity on approved countries for cross-border data transfers. And then countering what Nicolette said about sensitive and critical personal data, some people feel that the categorization was important because you cannot consider your health data or your financial data as the same at the same level as some other data, such as, for example, your Swiggy orders. So it's not supposed to be a broad personal data. There should be some categories over here. So that's one of the points that people have raised. Age of consent still remains at 18. Akshit went into in detail about why this could be problematic. And the definition of harm has also been reduced. Again, that was covered. That's it from us. This is our coverage. We have a guide which has the links to all our summaries and comparisons of the bill. And we are doing stakeholder feedbacks right now, initial impressions as well. You can find all of this in our archives.
If we could just go back to the previous slide, Sarvesh, I just wanted to highlight few things. Just go back to the previous slides. So for me, I think one of the most worrying aspects is the lack of purpose limitation on data collection. It basically means that whatever data you collect, it's not going to be limited by the purpose for which it is being collected, and people can use it for whatever purpose they want. And then there is an anomaly in terms of data retention, where they say that data has to be retained, can be retained for a specified purpose, and those purposes are either legal or business purposes, which is again really broad. This means that it significantly limits, to my mind, the right to data erasure, and that is going to be problematic for us when, let's say, if your data is being collected by someone for a particular purpose, and should be allowed to get it removed as and when the purpose of your sharing the data is served. So I think these are fundamentals of privacy legislation that we seem to be bypassing. The other one, I think, that is again problematic is the age of consent being still at 18, but also the verification of consent. I mean, there is no distinguishing between an 11-year-old and a 17-year-old, and it's not taking into account the increase in maturity of an individual, but also the need for exploration of an individual as they're growing up, and also doesn't take into account the issues regarding access to the internet, that the access to the internet is different for different genders, especially in rural parts of India. And the moment there is this overbearing requirement to get consent, it means that a large part of our population, especially girls, will be disenfranchised without access in terms of the access to the internet. There is also, one other part about tracking and profiling of children. So that there is certain kind of tracking and profiling which is useful for them, which means that you are, let's say, attributing a certain, let's say, if you're running an educational site, and then profiling actually helps improve recommendation of content to children, and personalized advertising of particular courses that might be relevant for that particular child. So if I do a pop-up of a course based on past performance that I feel that a child might need, and it's an indication for the parent to purchase that course, and that's what's wrong with that kind of profiling? What is wrong with that kind of advertising if it is meant to be useful to someone? Another thing is that there are mechanisms that platforms use for, let's say, determining, say, whether there's an adult that's posing as a child, and that's based on behavioral patterns on platforms, whether you're able to tell whether an adult is posing as a child or not. And so that kind of profiling will actually help prevent grooming on platforms. So again, I think it's perhaps we needed a separate legislation for regulation when it comes to children. Also to some extent, different platforms have different sets of behavior. So what are the norms that should be determined for that should be left to subordinate legislation. I think I'm going to disagree on a couple of points also. Like I think that the classification of sensitive and critical personal data is problematic because it's difficult to, the amount of data that exists. Everything is data online. That just segregation of data by itself is extremely difficult. And as someone who's largely opposed to the idea of data localization, I would say that personal data should be allowed to reside abroad. I don't see a problem with that. So I mean, that's just my take on it. Here we do at times disagree with each other, so I'm disagreeing with Sarvesh on this. But I mean, we have a bunch of questions. I think we should stop recording now. Could we stop recording, please, Rakesh?